Okay, folks, we are now moving on to Note 9, which deals with corporate directors, officers, and shareholders. First part of this deals with the role of directors and shareholders. Directors have the ultimate control over the corporation. They are usually directly elected by the shareholders. Their number and their term of office is controlled by the bylaws. The bylaws are a document that is drawn up as part of the creation of the corporation. It operates very much the way that the main body of our Constitution operates for our federal government. The bylaws state how the corporation is to be run and managed. It determines how many officers, what they're going to be, what their roles are. It determines how many directors there are. It states out when meetings will be held to vote for the various directors and officers, and basically sets up the mechanism for governing and controlling the corporation. Now, directors can be compensated, but they're not always compensated. You can be an officer as well as being a director in most corporations. In order for the directors to come to a decision that is binding, they must have a meeting, and a quorum must be present at that meeting. A quorum means a set number of votes that must be present before any item can be considered and can be voted upon. In most situations, 50 or 51% represents a quorum. In some situations, people are more conservative and they want 75% or 60% of the directors present to vote, and then whatever a majority of the number of people present decide on will be what happens with the corporation. It's kind of interesting because if your quorum is set at 50 or 51%, basically a vote of a majority of the people present, which would be 25 or 26%, can control what's going to happen with the corporation. So a quorum is put in to keep a few people from calling a meeting, being the only ones showing up, and being able to change the course, change the position of the corporation. But in reality, sometimes as few as 25% of the board of directors can be making the decisions as to what's happening. Usually there is one vote per director. They can set up committees of directors to review certain ideas and certain issues. There's a lot of freedom in how this can be done. Under present statutes in Massachusetts and Rhode Island, you need not have a physical meeting of the board, and this occurred prior to COVID-19 times. You were allowed to have a meeting by paper, by passing a resolution around, getting a majority of the directors to sign it. As long as you gave notice to everyone and made it clear to everyone what was happening, then you could do this. And in many small, closely held corporations, that is how we operate. We rarely hold physical meetings where we make the directors and the 4 or 5 owners sit down together to vote on something. What happens is there's an idea, it's talked about, it's discussed informally, and then we pass around documents where they basically vote by document and add to the minutes of the books of the corporation a paper meeting that was held where not everybody was present, but yet decisions were made. Directors have the right to participate in decisions. They have the right to have notice of any meetings. If they don't receive notice, then a meeting is not effective. They have the right of inspection. They can review the books of the corporation. They have the right to tour facilities, to speak with employees. While they don't supervise employees, they can hear what the employees have to say. Certainly in terms of any grievances from employees, they would have the right to hear that. They have the right to indemnification. If they spend anything in their role as director, or if, even worse, they are sued and a judgment comes down against them as a director of the corporation, they have the right to demand the corporation reimburse them for whatever expense or whatever judgment or liability they had to pay. Corporate officers are legally employees of the board of directors, and in most corporations, the way the structure works is that the shareholders vote for directors, and then the directors get together and they determine the officers. Now, in most corporations, you will have at least a president, a vice president, a secretary, and a treasurer. The president and the vice president are the day-to-day managers and controllers of what happens in the corporation. They have the duty of hands-on, day-to-day supervision. They can delegate this to managers and to sub-vice presidents, or there can be a number of vice presidents, actually, each of whom would have a specific area of expertise or a specific role to play within the corporation. Secretary is in charge of keeping the books of the corporation, which can be quite an intensive activity. They have to keep records of every meeting, of every vote. They have to make sure that shareholder lists are kept up to date and that shareholders receive proper notices, that board of director members receive proper notices. Treasurer, of course, is the position of the person who handles the funds, who does the accounting. Today, very often, we do not call the person the treasurer anymore, but it has come into vogue to call them the CFO, or Chief Financial Officer of the corporation, as opposed to the COO or the CEO, Chief Executive Officer, or Chief Operating Officer, which in some corporations now that person would take the place of the president. Although these people can also be, when you get into the CEO and the CFO, it could be that there is a president, and that president has decided to delegate duties to these folks and to take them over and to run with them. They would be employees of the corporation. The officers of the corporation are also employees of the corporation. Now, in most companies, particularly the large publicly traded companies, there is no prohibition that says if you're a shareholder you can't be a director or you can't be an officer, and there's no prohibition that says you can't be a director and an officer at the same time. So what you will find in many of the larger companies is that people who own a large number of shares, or who control a large number of shares because those shareholders back them, they will end up being not only shareholders but directors and officers of the corporation, and that is all allowed. It is perfectly acceptable. They have to be careful that they perform their duties towards the corporation, particularly if they're carrying a number of hats. They have to make sure that they cover their responsibilities for each of these hats that they are wearing, but it is not only permissible, but it tends to be the reality of how many corporations operate. Now, the duties and liabilities of directors and officers. They must exercise due care in making corporate decisions. Those decisions have to be made in good faith. They have to be reasonably prudent, and they have to be acting in the best interests of the corporation. Good faith means fair, open, and honest dealings in fact. Reasonably prudent means that they don't have to be 100% correct. They're not insurers. They're not guaranteeing that everything will come out well, but they still have to use reasonable business judgment, as we talked about in the last section, to make decisions about where the company's going. And acting in the best interest of the corporation is, again, they have a quasi-fiduciary duty to act on the behalf of the company and to put that before their own interests, and to certainly not vote in a conflict of interest situation where they'd be voting their own interests and not that of the corporation as a whole. The decisions must be reasonably informed, so they have to base their decisions on facts, on knowledge, on information that they have received, and they must exercise reasonable supervision. They can't just appoint a couple of managers to go off and run the company and not bother to check and see and bother to find out what is going on. If they do not do this and the company suffers a loss, the shareholders would actually have a suit against the officers or the directors for failing to fulfill their duties and making sure that the corporation was conducting its business properly and in a beneficial way for the shareholders, who are the ultimate owners. We talked about the business judgment rule in the last chapter. So long as an officer makes a decision that was informed, has a rational basis, has no personal conflict of interest, then they cannot be sued for their vote on a decision or their decision. If they operate in bad faith, fraud, breach of fiduciary duty, then all of those types of things overcome the business judgment rule and would make them liable for damages for their actions towards the corporation. Directors and officers have a duty of loyalty to the corporation. Loyalty means that in any circumstance where there's a conflict, They would put the business of the corporation ahead of their own business. They would put it ahead of the business of any other entities they were involved in, any other corporations or businesses they were involved in, and that they would not directly compete with the corporation or indirectly compete with the corporation. They would not grab an opportunity for the corporation, like a large client offering to come in and make a great deal. They would not grab that for themselves as opposed to making that available to the corporation. They would not pursue conflicts of interest, and they would not use internal information for their own personal gain. Now, this gets us into an interesting area. When we get into securities law, we're going to see that for not quite 100 years, probably about 80 years now, there has been a federal agency called the Securities and Exchange Commission that controls the buying and selling of shares of stock on the open stock markets and the sale of stock to the public. And they have a great deal of rule-making authority. And one of the rules that they made is about something called insider trading. Insider trading is when you, as an officer, an employee, a director of a company, maybe even not somebody employed by the company, but somebody who does business with the company, becomes aware of a situation that gives you a benefit in buying and selling stock that other people in the general public would not have. And this is illegal, and they do enforce this. Corporate executives and stockbrokers and stock traders and business people hate this rule because it's very easy to be tripped up in it. How do you run? How are you the president of a corporation and not be accused of buying and selling stock based on information you had if you buy or sell any shares of stock in your corporation or in a corporation that's doing business with your corporation? It makes it very difficult. Martha Stewart, of Good Housekeeping fame and of cooking fame and decorating fame, was caught up in this, where she received some information from her accountant about a stock deal and traded on it, and when she was challenged by the SEC on this, she lied about it, and she was ultimately convicted of lying to the FBI or lying to a government official. But the basic thing that tripped her up was a charge of insider trading, of using information not available to the public to influence the stock market or to take some type of gain or advantage in the stock market for herself that was not available to other people. In conflict situations, an officer or director may pursue their own interests so long as they make full disclosure of what's going on and they tell the other officers and the other members of the board and possibly even the shareholders what is happening, and that they are going to pursue a certain avenue. Now, liability. Officers and directors can be held responsible for the crimes and torts of the corporation. They can be held responsible by shareholders who have the right to bring something called a derivative suit. If the shareholders feel the directors and officers are not managing and running the corporation correctly, they have the power to go into court and sue them, seek their replacement, seek damages from them. So directors and officers can be held liable, both criminally and civilly, and so therefore they need to be careful in their activities. They need to have an understanding of what's going on and not just be a rubber stamp. By saying rubber stamp, I mean in many situations, many corporations develop and grow through basically the expertise, the knowledge, the creativity, the force and drive of one or two or a few people. And as they get bigger, they create boards of directors, they create officers, but there is a great human kind of desire to go along and get along and not to buck the powers that be. You really have to be very careful if you're a director or an officer. You will be deemed to know what was going on in the corporation, and failure to know would be a proof of negligence. So if something happens where the corporation's being sued or going bankrupt because of mismanagement, and you as a director just really didn't get involved, kind of sat back and let happen what happened, you could still be held responsible for not exercising your duties as a director. Now, shareholders have no right to the legal title or to corporate assets. They have an equitable interest in the corporation. They are a percentage shareholder of the corporation, but what that ownership gives them is the right to vote for directors and the right to receive profits, to receive dividends from the company, and the right to buy and sell their shares if it's not a closely held corporation. Normally, one share of stock gets one vote in the corporate structure. And however, things can get very interesting because unlike with political elections, where up until very recently you had to show up at the voting machine to cast your one vote, for over a century now, shareholders have been able to sign or create something called a proxy. A proxy is basically a written statement giving your share to someone else. And one of the way that people get to be directors or officers of a corporation and maintain those positions is that they actually campaign. They solicit proxies from as many shareholders as they can get, hoping that they could walk into whatever voting meeting is happening with a majority or very close majority of all the votes that can be cast. Once a proxy has been given, the person who holds the proxy has a right to vote it as if they were the shareholder. Proxies can be revoked unless there was some financial exchange or contract signed concerning the proxy. They are very powerful things, and they are one of the reasons why very often even large corporations with millions of shareholders seem to be basically controlled by 10 or 15 people. A large number of shareholders take very little interest in what's going on other than when am I getting my dividend and what is the price of my share on the open stock exchanges. And in exchange for that, they will happily sign over their proxies whenever they receive a letter asking them to do so. There are quorums for shareholders' meetings. But here it's not a certain number of people, but a certain number of shares must be present and able to vote, and again, usually 50% or 51%. The corporations are required to keep lists of their shareholders, and these are for two reasons. Most corporate bylaws mandate that a shareholder must be listed on the books of the corporation before that shareholder can vote their shares. So this, in effect, keeps someone from buying several thousand shares of stock the night before a corporate vote and then showing up and claiming, well, I now have this interest, or I have this majority, or you have to listen to me. Normally, with the larger corporations, it takes upwards of a month to get your name listed on the books of the corporation, and it's only after that point that you can actually exercise your right to vote. Voting lists also must be kept because shareholders have the right to obtain those lists. If a shareholder wants to solicit proxies from other shareholders, he has the right to get the lists of all shareholders so he can begin his campaigning. If some shareholders feel that the corporation is being mismanaged, they have a right to get the list of shareholders so that they can contact them and seek their aid and assistance in whatever the disgruntled shareholders want to do by way of suing the corporation or the directors or the officers. These lists, as we said, are available usually for shareholder inspection. Some corporations have something called a cumulative vote written into their bylaws. Now, what happens with a cumulative vote is, let's say there are 12 members of the board of directors, and they are all coming up for their term at the same time, which usually would not happen. The terms would usually be staggered, where 3 or 4 a year would come up, and there'd be kind of a rotation in that way. But let's just say we're in a company where there's 12 directors. They're all coming up to be voted on at the same time for renewal of their terms. In a situation where there's cumulative voting, every share would have 12 votes. They would have one vote for each position that was vacant. Now, normally you would think, like in a political election, well, you have one vote for the president, one vote for the senator, one vote for the representative. There might be 10 people running, but you have to cast a vote for each position. With cumulative voting, that is not true. If each share is given 12 votes, they can cast one vote for each of the 12 members, or they can take all 12 votes and put them on one member, which makes it possible for factions and groups of people to acquire large numbers of votes to get a particular person or persons on the board, if that's what they're intent on doing. So it's kind of an interesting thing, very different from a political voting process. Right? Also different from our political voting process. Shareholders can enter into voting agreements, voting trusts. They can pledge their votes in advance as to who and how they would vote. So it's much different, much more flexible, much more dynamic in many ways than our political process of voting. Now, some of the rights of shareholders. When you buy stock, whoever stock you purchase, their stock is sent to the corporation to be transferred to you. In the old days, this was done with paper. The old share would be turned in. The company would issue a new share with the new shareholder's name on it. It would be signed and sealed by the secretary and treasurer of the corporation, and the new shareholder would, in the mail, at some point receive a paper stock certificate saying you now are the proud owner of X number of shares of XYZ Corporation. Today, this is all done by computer 99% of the time, so you don't actually get a physical piece of paper to evidence your share. You'll be added to the list of shareholders in the computer. You'll get periodic statements, either monthly or quarterly, depending on how the corporation is set up, and your ownership rights will be stated in those statements that you received and will be contained on the books of the corporation, but you don't have a nice looking certificate from General Motors or from Microsoft to hang on your wall as a shareholder. In closed corporations, very often the stock certificates are coded with information stating the rules that may prevent them from being sold to outsiders, being sold to third parties without the permission of the other shareholders. Very often the shareholders, the existing shareholders, will have preemptive rights, meaning that they have the right to buy in at whatever a third party would offer for the closely held shares, and the other existing shareholders would have the right to grab those shares rather than letting them go to a third party. Stock warrants are something that gives you the right to purchase stock at a guaranteed price in the future. Corporations sometimes issue those to raise money. There is also particularly with startup businesses, there's a very big market now in futures, in signing up for a promise to be given stock at a point in the future when the company is making money. So by investing, particularly if you are a private investor in a new corporation, instead of taking anything right now, what you might be given is the promise that when the corporation does go public, when it begins to offer shares, you will be given those shares, usually at a guaranteed price, and you will have first bid to buy them before they are issued to the public. And again, that can become very valuable if the company has suddenly made good on some business adventure or some product that they're making and selling. Shareholders have the right to inspect the financial books and the shareholder lists. Other than that, they don't usually have the right to inspect day-to-day correspondence of the corporation. Certainly, if there was a lawsuit, most of that can be gained through discovery, but in terms of a shareholder has no right to go in and say, I want to see all the emails between the president and the vice president of the company for the last year. Shareholders are allowed to submit proposals for consideration at the annual meetings, and most companies do have annual meetings of their shareholders. All right. What else do I want to tell you about shareholders? Shareholders have the right to receive dividends. So when the corporation is making a profit, part of that profit is to go to the shareholders. Now, it's a very convoluted and complicated thing. Not every company offers dividends every single quarter. There are times when the companies are not making enough money to feel like they want to disperse all their funds that they have on hand. There are times when they're saving up money to invest in some new adventure, to hire new employees, to build a new building. So depending on how the bylaws are set, depending on how the stockholders have voted at the last several meetings, there can be long periods of time when shareholders go without getting dividends in the corporation. But the general idea of a well-run company is that they will, on a periodic basis, be paying out dividends to the shareholders. This is what keeps the shareholders happy, keeps them voting for the board members. And of course today, one of the other things is having the shares of stock go up in value on the open market. So shareholders are really looking for two things. They're looking for dividends. They're looking for the value of their stock to increase so that when they go to sell it, it'll be worth way more or much more than what they had paid for it. And really, if you want to maintain your position as a director or as an officer, those are two goals that you have to constantly keep before you and keep in mind, because ultimately the shareholders have the final decision-making power, and if you anger enough of them, you will be out. Upon dissolution, if the company dissolves, if it's going out of business, the shareholders have a right to receive a pro rata share of whatever assets are left. Now, if the company goes into bankruptcy and there are not enough assets to pay the creditors, the people that the company owes money to for loans and for business dealings, then the shareholders get nothing. And we talked a little bit about in the last section that if you have preferred shares of stock, when it comes time for a liquidation, the preferred shareholders will receive refund on their equity first before the regular shareholders or the common shareholders do. So very often when corporations go out of business, there is nothing left for the shareholders to receive. Shareholders have the right to bring what's called a derivative suit. So if the shareholders feel the corporation is being mismanaged by the officers, by the directors, they feel that actions are being taken that are detrimental to the corporation, they have the right to bring a lawsuit saying, look, these people who are in charge are messing things up, they're ruining the corporation, we want the court to enter an injunction to stop them, we want to hold a new election, even though it's not time for one, we want to appoint a new board. They can ask for almost any kind of equitable relief in court that they would seek. And the idea being that if they see that the board and the directors are running the corporation in the grounds, they have access to the courts to protect their rights, to protect their interests. When corporations try to raise money or need to raise money, one of the things that they could do is sell shares of stock. Many corporations are authorized to issue millions of shares of stock, and they rarely ever issue them all at once. So very often you have situations where the corporation is sitting there on its books. It may have 500,000 shares outstanding held by members of the public, but it also has 500,000 shares sitting on the books that they could take and they could sell in the open markets. That creates a difficult position for the existing shareholders because, in effect, if the corporation sells that second 500,000 block of shares, the ownership rights of the original shareholders will be cut in half. And there are legal mechanisms where the shareholders can prevent that from happening. They can go to court and stop it, particularly if it's a situation where there are a majority of shareholders who presently control the corporation and there's a minority of shareholders, and now we're going to issue shares of stock that make the minority an even smaller minority, is going to lessen the value of their holdings and their interests. The majority shareholders and the directors and officers that they have elected have to be very careful, because the federal courts in particular have held that minority shareholders have rights in these situations to prevent their investment from being watered down. And we actually call that in some situations selling watered stock. Watered stock would be when the corporation issues its shares to people far below the value in the open markets. And again, by doing that, they're giving these people a benefit that should be going to the existing shareholders, and they are lessening the ownership interests of the existing shareholders, and courts have stopped that from happening on a number of occasions. All right, that's about all I have to say on Note 9. We'll be moving along into Note 10, upwards and onwards.